Hello. The topic of today's talk is licensing. My name is Christoph Karl, and I'm here with my partner, Pascal Böhner.
Hello.
The two of us have been cooperating on various licensing projects in the recent years.
And today we don't want to show you the very basics of license agreement or a complete list of provisions, rather highlight specific issues we consider to be very important to look at. So one of these issues, Christoph, what could it be?
Well, one of these issues comes about in the context of exclusive licenses, and that's the one of minimum royalties. When an exclusive license is concluded, the amount of money that the rights owner makes with his IP entirely depends on the extent of the use of the IP by his licensee.
Yeah. And if the licensee, he only has a right to use, not an obligation, so if he doesn't use, the licensor ends up without any revenues from the license agreement.
And therefore it is crucial for the licensor, and it is surprising how often it is not being done in practice, that some provisions about a minimum royalty are put into the license agreement.
Yeah, and sometimes if licensee don't accept that, you can provide for something like you lose your exclusivity, or there is a termination of the agreement when these minimum royalties are not reached.
Another such issue that oftentimes comes up is if during the execution of the license agreement, there's a third party which shows up and which infringes that IP. Who can sue this third party, or who should even sue that third party?
Yeah, that's also a very important point. You have to distinguish between non-exclusive and exclusive license agreement. Because typically where you have a non-exclusive license agreement, it's only the IP owner who has the right to sue because he's the only one having an interest in the IP and in defending the IP against third parties. Whereas in exclusive license agreement, the interests can be completely different.
That's right. The licensee, of course, may have an interest to bring a lawsuit because that third-party infringer is competition to him, and that competition he makes without paying any license fees to the licensor. On the other hand, also the licensor can have an interest to sue because if his licensee is given competition and if his licensee is in trouble, he will make less revenues, at least in the case of running royalties.
Yeah, that's why in many jurisdictions you have both of them, the licensee and the licensor, having a right to sue. In Germany, this applies to patents, for example. In trademarks, it's different, where you need the consent of the licensor before the licensee can actually raise claims, be it in a warning letter or in a lawsuit, for infringement of the licensed IP right.
That's a good example of how the rules differ between different sorts of IP, and they certainly also do differ between different jurisdictions, and therefore it is good practice to include a clause in the license agreement which regulates that issue to have clarity.
Yeah, and I would even say when you do this, when you add this to the agreement, you should also consider that both having a right to sue can lead to questions and conflicts. For example, who then has to bear the costs of the litigation? Who is responsible for defending the IP rights? And in case you win the lawsuit, who gets damages or anything like that? So all this needs to be taken into account when drafting these respective provisions. One more thing, we already mentioned that the licensor has an interest in terminating the agreement when the performance of the licensee is not as expected. But when does the licensee have an interest in terminating the agreement?
He absolutely may have such an interest. Imagine a case where a patent is licensed out, and during the performance of the agreement, a new piece of prior art comes up which is really strong. In this situation, the licensee knows that he's paying for an invalid patent while all his competitors can use the technology for free. So he would like to get out of that contract.
But I assume he can invalidate the patent. Any non-attack clause would very likely not be valid, at least under EU antitrust laws.
He could do that, or he could try to do that, but it would take him something like 4 to 5 years in Germany to sue the patent entirely invalid in first and second instance. And during all that time, the license fees accrue.
Yeah, and he will not get these licenses back, at least under German law. There's a rule that you don't get these fees back. So this is another example what to think about when drafting the agreement, and to take into account that you need these termination clauses and address that issue in the clause as well.
So Pascal, in practice, who is it who should draft such a license agreement, if not the two of us?
Well, I think it should be someone with an IP background and someone who is familiar maybe also with litigation. So if you need more information on licensing, look out at our website. Thank you very much.